Hi, everyone. This is attorney Shilpa Malik, the managing attorney at Visa Nation Law Group. I'm here today because I wanted to talk to you all about an important immigration update. I'm sure by now most of you would have heard about the major immigration update as it relates to F-1 students and J-1 exchange visitors. So let's talk about it a little. The Department of Homeland Security has issued a major new rule that will significantly change how F-1 students and J-1 exchange visitors maintain lawful status in the United States. These changes are taking effect on September 15, 2026, and if you're currently studying in the United States on an F-1 or a J-1 visa, this is something you absolutely should know and understand. For decades, most F-1 and J-1 exchange visitors were admitted for what is called duration of status or DS. This meant that as long as you were maintained your status and your school or program properly updated your service record, you could generally remain in the United States for the duration of your academic or exchange program. Unfortunately, that framework is now changing. Beginning September 15th of this year, F-1 and J-1 visa holders will generally be admitted for a fixed period of stay tied to the end date on their Form I-20 or DS 2019, but generally not exceeding a period of 4 years. Your Form I-94 will become far more important than it has been in the past. Now, why does this matter? This is important to know. Because extending your academic program through your DSO or designated school officer will no longer automatically extend your authorized stay in the United States, if your program continues beyond the expiration date on your I-94, you may and most likely will have to file what's called an extension of stay I-539 application with USCIS before that date, which is the date of your I-94 expiration, or depart the United States and obtain a new period of admission. The rule also shortens the F-1 grace period after completing your studies or practical training from 60 days to 30 days. Again, the grace period will now only be 30 days, not 60 days as it has been for such a long time. This means that students will have less time to transfer schools, apply for a change of status, plan for departure, or take other steps to maintain in lawful status. Therefore, early planning is extremely important. Now, this is a significant procedural change. Doctoral students, researchers, medical trainees, and anyone enrolled in programs that are expected to last more than 4 years should begin planning well in advance because an additional USCIS filing may now become necessary during the course of their studies or program. Perhaps most importantly, students should no longer assume that an updated I-20 alone authorizes them to remain in the United States. Going forward, carefully monitoring your I-94 expiration date is extremely critical. Even a short overstay would have significant and serious immigration consequences, including the accrual of unlawful presence and the potential voiding of your visa under Section 222G of the Immigration and Nationality Act. This is one of the most significant changes to student immigration rules in many years, and we expect additional guidance from DHS, hopefully, but also from our American Immigration Lawyers Association as this rule begins to get implemented. Now, again, if you have any questions about how these changes would affect your situation or if your program is expected to extend beyond your authorized admission period, please consult with a qualified immigration attorney well before your status expires and don't wait till the last minute. Thank you for being with me this morning, and we'll continue to keep you updated on important developments in U.S. immigration law. Have a great day.